requested for a variation of the freezing order so that the bank accounts that belong to the Jammeh Foundation Hospital would be released. Another example, the current Deputy Speaker requested an audience to see me, Honorable Sidi, because the APRC political party bank accounts were frozen, and in fact he was supposed to come with the Speaker, but then he ended up coming alone, and just to demonstrate my openness at the time to meet with everyone irrespective of their political orientation. I was there for everyone, not just for a particular section. So I received him in my office, and he came to ask that we unfreeze the APRC bank accounts, because the bank accounts were not Jammeh's, they were the parties, and it was monies in the accounts were the result of contributions from individual members of the party. And he will tell you that I told him I am in principle open to unfreezing the APRC bank accounts if he can bring evidence to me to show that these were indeed the contributions of individual members of the party. That's what I told him, and I was going to do that if he had demonstrated at that point that the APRC accounts were the result of individual contributions from party members. He never came back or produced that evidence, and so the account remained frozen, just to illustrate that we were open to dealing with people fairly. So what we did, we took a default position and froze all, and then on a case-by-case basis, when people make claims that we thought were meritorious, then we reacted to those claims. So that's what we did to ensure fairness.
Okay, I will get back to the assets again. I however, would like to know the assets investigation prior to going to approaching the High Court. Did the government see it as part of rebuilding trust in state institutions after the former regime had taken off?
I wouldn't want to claim the role of spokesmanship for the government, because when you say the government, you're now making it a little bit more fluid. Let me tell you what I and my ministry did, what we were thinking about when making those decisions and taking those actions.
Sure, you can do that. However, we would also like to establish one thing: the ministry is not acting in isolation.
Absolutely,
it acts on behalf of the government. So whatever actions the ministry takes is part of the government.
In fact, to even go further, every action that the ministry took at that time was based on a government policy decision.
Precisely, and that's why when I refer to government, I believe since the ministry was saddled with most of the affairs surrounding the commissions, and particularly this commission, it would be fair to say that you could speak on the mind of the government at the time.
If that's the approach you want to take, I don't have a problem with that. I can live with that. So if you don't mind, please repeat that question again, the last one you asked.
Did you see the assets investigation as part of a rebuilding state trust in state institutions after the former regime?
I keep repeating myself. As at that time, the processes that we thought would engender trust in the reform processes that we were going to embark upon did not include the assets. The assets, again, were not an issue of governance. The assets are not high on the priority list of the government, because we were embarking on a transitional justice process with little resources at that time. And so our priority was to devote those little resources to the most urgent and most pressing matters of state, particularly governance, because the whole idea of the change of government to change the governance architecture, and we didn't take our eye off that ball, and that's our focus, to be honest, was on those issues rather than the issue of the assets at that time. If you are allocated few resources or fewer resources, you have to prioritize your activities. And that's what we did at that time, and the assets were not high on our priority list. So the issue of engendering trust wouldn't even arise insofar as the assets were concerned, because we wanted to engender trust for the more pressing matters of governance. And I can elaborate on some of these activities if you want.
That's fine. I believe you have alluded to them, the security reforms and
there's a whole host of them.
the TRRC, etc.
The CRC, you know, quite a lot.
Yes. But for some strange reason, despite all those pressing issues, this was the first initiative of your ministry.
It was the first major activity in our transitional justice process.
Yes, indeed.
Absolutely.
So how do we reconcile that?
It was a low-hanging fruit. when you have a whole host of activities to do, notwithstanding the fact that an activity may not be high on your priority list, but if it's a low-hanging fruit, if it's something you can settle very quickly and get it out of your way while you focus on other things, you do that. You do that, and that's what we did in the case of the commission.
Now that's interesting. It was a low-hanging fruit. However, your testimony here also alludes to perhaps the unpreparedness, for lack of a better word. I'll give you a minute. My apologies.
Go ahead.
My co-counsel says I must say sorry to you. All right. Are you much better?
No, go ahead. I'm fine.
All right, that's fine. It was not a priority. However, it was a low-hanging fruit. And you have alluded to in your testimony the fact that it was something you were not too prepared for. Would I be right in making such a statement?
Too prepared for. It was something that we did to the best of our ability, given the resources that we had at that time.
You know, we had a witness here the other day that said, everybody is wiser in hindsight.
You can say that again.
And I would like to ask, in hindsight, do you believe the ministry was ready or the government was ready to undertake this task?
If you were to give us the environment, the same environment today as we had at that time, I have to say we even exceeded expectations given the challenges that we had. Now, in today's Gambia, where things seem pretty settled, if you gave me that task, I would do it differently. There's always room for improvement. There's always lessons to be learned. And I believe I said this 5 years ago in my farewell statement, that in hindsight, certain things could have been done differently. There was always room for improvement. So that is just the nature of human beings. It's good to have self-reflection and to admit that no system is perfect, that there's always room for improvement. So if I were to do it today in this environment, I would do it differently. You would have a much improved version of events. But if you were to transpose that same environment today, I would do exactly what we did then, because that was what we had at that time.
Fair enough. Let's go back to the FIU report and the other reports. Were these reports, pardon me, you had mentioned that the reports were discussed in cabinet.
The report was handed over to me by the late Secretary General, and I took it to my office and had a meeting with my team, and then instructed the Civil Litigation Department to prepare the applications based on that report. Yes. I'm not sure if the reports were discussed in cabinet, but I did make a request for information that I could use to go to court in cabinet. Those were discussed in cabinet.
So it was understood from your proceedings in cabinet that information would follow on and you would act upon that information.
I was very clear. It was very clear, and in fact, I recall there was a cabinet meeting when I was asked, after a few weeks of nothing happening, I was asked why I wasn't doing anything about the assets, and I said I haven't received any information yet, and I believe the President intervened and requested the Minister of Finance to help me get that information. So just to say that everybody knew that I wasn't going to go to court empty-handed. I wanted something, and if they were not going to produce that thing, I was not going to court.
All right. All right. I would like to cast your mind back to that preparation to go to court. But before that, were there any meetings after you received the report from FIU and the various other reports, but before you proceeded to file the suits in the High Court?
Any meetings where?
Anywhere.
Within my ministry?
Within your ministry, in cabinet, with stakeholders?
No, at that point, there were fewer meetings in cabinet on this issue. So it was a question of implementation now. And so obviously I had meetings with my senior management. I recall certainly having a meeting with the former Solicitor General and some members of the Civil Litigation Department, because when I received the information, I summoned this meeting at the ministry. I was the one who personally raised the issue of the implications of a freezing order, i.e., I wanted to avoid as much collateral damage as possible. There were ordinary citizens who were working in these companies that the former president owned, who were earning a living from these companies. And if we were to impose a blanket freeze on these companies and their assets, all of those people will be out of work, and the businesses will be shut, and that's the end of the story until a determination is made subsequently as to what to do. So in consideration of those people, I told my team to see how best we can freeze these assets and then entrust these companies, a sector, to a third party who will continue the business and allow these people to continue their work while the government decides what to do subsequently. And the civil litigation came back to me with a proposal. They came up with the Anti-Money Laundering Act and said there is provision here which allows us to freeze the assets and to entrust the assets to a receivership, so that the receiver will act as interim caretaker over the assets, continue to run the businesses, people will not lose their jobs, while the assets will also not be dissipated. Because the whole idea of applying under the Anti-Money Laundering Act is to prevent assets being dissipated by the subject of investigations. And so it was that we agreed to use the Anti-Money Laundering Act and submitted our application to freeze all the assets.
Correct. I can sense that you're eager to speak about the High Court orders. However, before we get there, the committee has received evidence that a meeting was held at the MOJ with stakeholders prior to the suit being filed. And some of these stakeholders would be personnel from the offices of Augustus Prom, the chartered accountants, and some other personnel, including the registrar of companies at the time, and the registrar general as well, to prepare for what is to come, what is about to come. Can you confirm such a meeting?
That one is a difficult one for me, because first, as Attorney General, I'm only responsible for policy, not implementation of that policy. So I wouldn't know much about the operational details. But two, also because when we were making the decision to freeze the assets, there had to be an element of surprise in that decision. It's like a police going to do a dawn raid. They don't inform the suspect that they were coming to conduct a raid.
Of course.
So it was a similar situation. We were about to freeze the assets. But if we let that information out, there are people who would take advantage of that situation and try to dissipate some of these assets. In fact, to give you an example, soon after when I announced the freezing of the assets in a press conference, a senior counsel called me to say, and this is before we actually wrote to the different banks, wrote to me and said, a bank has called her, because she was counsel to the bank, and said there were attempts to withdraw money from one of the accounts that we had identified. But luckily, the senior counsel was experienced enough to advise the bank not to allow that, because even though we have not yet written to the bank and officially notified them, my press conference served as constructive notice to the bank. And so they couldn't ignore that. Just to say, to basically relate it to the fact that I would have been very surprised if a meeting was held before with all the stakeholders, because of the risk of dissipation of the assets. So it had to be a very small group who knew of our decision to freeze the assets. Certainly, we had meeting with Augustus Prom, because I was actually involved in that part as well. So we can come back to that. But in terms of the wider stakeholder group who were to implement the order, I wouldn't have thought so, but it's possible.
All right, so there was a meeting, but it was a very small meeting. So
yeah, myself, maybe 2 or 3 members of the civil litigation department.
What about the Registrar General?
I do not recall the Registrar General being in that meeting. I do not recall that.
But Augustus Prom was in that meeting.
Augustus Prom came to see me after, because there were 2 meetings. They met with Augustus Prom separately, and then, or maybe after my meeting with Augustus Prom, but certainly Augustus Prom did come to see me, because I was the one who asked my civil litigation department to contact Augustus Prom for me and invited them to a meeting in my office.
Now, the evidence the committee received from 2 witnesses, the first being the Registrar General at the time, places you in a meeting. Of course, I do agree with you that your portfolio is policy. However, from what the committee received, that was a policy briefing meeting to equip them in their implementation once an order was sought and granted. Does that refresh your mind?
I wouldn't rule it out. Like I said, it was a small group, because we didn't want the information to go out. So if the Registrar General, who was going to be one of the people who was going to be given a responsibility in that order that we were seeking from the High Court, it makes sense that he would be in that meeting. I cannot recall. Who was the Registrar General at the time? Aliou Jallow?
Yes.
Aliou Jallow. It's possible I will not rule out the fact that he would have been in that meeting. But because you mentioned other stakeholders, I was thinking about the operational meeting that he held with third parties outside the ministry.
Yes,
But
he mentioned 2 meetings.
yeah, but in terms of the minister, it's very possible that he was there as well as Registrar General. I will not rule that out.
Okay, so a meeting was held to discuss the policy issues that perhaps may arise from the entire activity that you were about to take part in.
Mm-hmm.
You received reports. Those meetings were held. Can you take it from there?
A decision was made to apply to freeze the assets. As I said, in consideration of those who were still employed in these companies,
So perhaps, if I may guide, prior to instituting the suit and approaching the court on an application, were there any other activities perhaps that may be of guidance to this committee?
activities such as
I would want to know anything to prepare for the suit.
well, yes, there were meetings, certainly. I think there were a couple of meetings. The final meeting perhaps would have been this meeting where the former Registrar General said he attended to make sure that those who were going to play a key role in the process were informed beforehand. But there were meetings prior to that. For example, there was a meeting to decide who in government, which government department was going to be entrusted with the different kinds of assets. For instance, the cattle. We thought it was best to entrust the cattle to the Gambia Livestock Marketing Board or agency. I can't remember now. So they were identified as the appropriate government department to take care of the cattle. The wildlife, the crocodiles, the hyenas in Kanilai, we identified those wildlife. And who else? Well, we had Augustus Prom, who was to take over the companies as receiver, and then the Registrar General as well. So we had identified strategically, because a lot of thinking went into this. As I said, we didn't just want to get up and go to the court and freeze the assets and then realize the ministry doesn't have the expertise to deal with cattle or wildlife sector. That's why we considered all of these different government departments and entrusted responsibility to them. At the time, I understand there was reluctance after the order because some of them complained that they didn't have the capacity.
All right. Before we get to the order, I know I keep teasing you with the order, and I promise you we'll get there, Mr. Tambedou.
No, it's okay. Maybe.
I'm interested in those meetings and the result of those meetings, because you have rightfully mentioned that before approaching the court, you needed to put your ducks in a row and ensure that all the properties were in proper custody once the order was granted. Now, the decision was made from an internal meeting, correct? Did the ministry communicate that decision prior to going to court to these respective players? Now, I do understand that for Augustus Prom, in the meeting that he was invited in, he would have been briefed,
Yeah.
and he would be on standby. What about Parks and Wildlife, Gilma, and all the others that the Ministry of Justice had identified to be custodians of assets? Were they communicated to as a result of that meeting?
To the best of my recollection, no. And there was good reason for that. As I said, the application was going to be strictly confidential, and we didn't want to have that leaked to avoid people taking advantage to dissipate some of these assets, or to continue to dissipate some of these assets. And that is why I would have thought no one had communicated. It's certainly not under my instructions, and I believe they were not informed beforehand.
All right. So, to the best of your recollection, the personnel that were informed were perhaps the Registrar General and Augustus Prom.
Most likely, yes.
And then yourself and your Solicitor General.
And one or two members of the Civil Litigation Department.
Team. Okay. Now, when it came to the receiver, Augustus Prom, how was he identified, and how were they identified, and were they the only firm or persons considered?
So when we decided to use the Anti-Money Laundering Act, which provided for the possibility to appoint a receiver in the interim, I had another meeting with usually the same management team, the Solicitor General, one or two, perhaps 2 or 3 from the Department of Civil Litigation. And so we started to discuss who to entrust, which receiver to entrust these companies to. I recall at the time there were 2 or 3 names that were floated in this meeting. One of them was Augustus Prom. The other one was Alpha Barry. I'm struggling to remember the third who was mentioned. But in any event, amongst those who were mentioned, this small group, I was advised that Augustus Prom had prior experience dealing with government, because he was the one who was entrusted with the process of liquidating the Carnegie company. I'm not sure if you are aware of the Carnegie company, but there was a Australian mining company here that had a dispute with the government and which went into liquidation. So Augustus Prom was the one who was given that responsibility, and so he had an edge over the 2 orders, and I decided to go with Augustus Prom and requested the Civil Litigation Department to contact him for a meeting with us at the ministry.
All right. And just to answer your question, I do know about the Carnegie company. Thanks to records, I've read the case. So, as promised, Mr. Tambedou, we can now go to our beloved High Court order. But since we're at the order, and you and I both know that the order cannot come in vain, it needs to come behind a suit. Please guide this committee as to how the suit came, what the government was requesting in the suit, what was the claim?
I want to believe that this is not a memory test. So if you have the application before you, kindly provide it to me. I can refresh my memory and tell you.
So I'm not speaking of the application just yet. I'm speaking of the writ.
But yes, but what about the writ?
We do not have the writ before us.
You don't have the writ from the High Court? Or
we
the
do
ministry?
Not have the writ. However, if you could give us information as to what the claim of the government was before the courts. If you can remember. If you don't remember.
Oh, no, I certainly remember the crux of the application. I cannot forget these events.
Not the application. You know, before the application can be filed, a suit needs to be filed.
No, there was no suit here.
There was no suit.
You should look at the Anti-Money. Do you have a copy of the Anti-Money Laundering Act?
Yes, we do.
Can you share it with me, please?
You will be provided with a copy.
Please.
You wish to refer to it now?
Yes, if it is convenient for you.
Secretary, please provide the witness with the anti-money laundering.
May I read you a provision of the Anti-Money Laundering Act, Section 51?
Please,
in particular,
proceed.
for the record. Section 51 of the Anti-Money Laundering Act, restraint of property. Subsection 1 reads, where a competent authority investigating a criminal conduct, a money laundering offense, or a financing of terrorism offense has reasonable grounds to believe that any money or property relating to the criminal conduct, money laundering offense, or financing of terrorism offense is held or is under the control of any person, the competent authority may apply to the court in accordance with subsection 2 for a restraint order prohibiting the person from disposing or otherwise dealing with that property except in such manner as may be specified in the order. So clearly the provision is self-containing. There didn't need to be a suit precedent to the application for the freezing order. It was premised on this provision, and that's what we did. We submitted our application to the court under the provisions and under exactly this provision.
And at the time of submitting that application, are you telling the committee that there was no suit before the court?
There was no substantive, there was no suit before the court, yes, in short.
All right. I would allow you liberty before I weigh in on my questions about the order. Please explain the genesis of the order and just a synopsis of what the order contains.
Well, after we received, as I said, the information from the FIU, we saw...
Would you like a copy of the order to facilitate your answer?
Not yet. I can provide the COX, and if you have further specific requests, I can look at that.
All right.
But
Perhaps
for now, I'll tell you.
In the meantime, I can ask the Secretariat to identify the order. That is MOJ 5A for the witness, Mr. Tambedou.
We considered, following the information from the Financial Intelligence Unit, which included information that were suspect, and which we thought established on a prima facie basis at face value some money laundering related offenses. And so we relied on those provisions and that information and submitted an application to the court asking the court to freeze a list of bank accounts and properties that we attached to our application until the competent authority concludes their investigation. The competent authority in this case was the Attorney General, who was filing the application on behalf of the state in accordance with the State Proceedings Act. And so it's unfortunate, again, I'll come to that. We require a lot of civic education in this country. Many people, because it's the Attorney General who instituted this suit, they personalized it and made it my suit. But it was being done on behalf of the government. It was a government decision. And so we requested the court to freeze the assets that were attached to the list that accompanied the application until the competent authority, in this case the Attorney General, concluded his investigations.
So you approached the court and essentially got a court order. It was granted.
Indeed.
Now, after it was granted, to the best of your knowledge, were there meetings, or did you authorize meetings between the MOJ and all the stakeholders as it relates to the order?
I instructed my staff to convene meetings with all the stakeholders who had a role in the court order. Indeed, and that meeting was held, I believe.
Did your staff report to you the events of that meeting?
I recall receiving reports, yes, about the meeting.
Were they in the form of minutes or?
No, it was during oral briefing.
It was an oral briefing.
Yes, oral briefing.
Who determined which institutions would be included in the process?
It was after consultations within the ministry, myself, the Solicitor General, members of the Civil Litigation Department.
What about Cabinet?
No, Cabinet did not participate in that process, as far as I recall.
So once the MOJ had gotten the order. And perhaps let me rephrase that. Once the government of the Gambia had obtained an order from the court, because I guess you're alluding to the fact that the AG, or rather the Attorney General, acts on behalf of the government.
Certainly.
And since it's only the Attorney General's name there, you wanted to refer us to the State Proceedings Act to say that the Attorney General's name is there to act on behalf of the government.
Yes.
All right. Now, once we can agree that it's the government who obtained the order. Once the government had obtained the order, is it fair to say that the government was on notice?
Oh, absolutely.
The government knew that there was an order.
It was the government that requested the order.
Precisely.
Exactly. Yeah.
Now, from the perspective of a third party, the government was aware of the order. However, the committee has received evidence to say that elements within the government did not get wind of the order. And it begs the question, were institutions that would be included in the process given notice after the order was obtained?
That should have been done. Every stakeholder that had a role in the order ought to have been informed of this order, and I believe that was done.
Mr. Tambedou, would you be surprised if I tell you now that a chunk of offices did not get wind of the order?
Like which ones? Give me an example.
The committee has gotten evidence, or has received evidence, from the department responsible for livestock, stating that they were never in receipt of the order. At some point, they were communicated to by their parent ministry, which is the Ministry of Agriculture, and they responded to the letter for further instructions, which were not forthcoming. The ministry, rather the agency responsible for wildlife as well, did not receive the order, or did not get wind of the order.
May I?
Please.
Council, government functions in a particular way. Each ministry has departments under them. So, Department of Wildlife, say for example, is under the Ministry of Environment, is the line ministry. Department of Livestock, the Ministry of Agriculture, is the line ministry. And so, if communication is emanating from the ministry, from the Solicitor General, it would be addressed to the permanent secretaries of these ministries, who will then communicate the information to their departments. The Ministry of Justice cannot write directly to these departments, unless, of course, as a follow-up subsequently over a matter that has already been initiated. But otherwise, as the first port of call, the ministry is the entry point for communications with departments under that ministry. And I would like to think that the Ministry of Justice would have written to the Ministry of Agriculture and Environment to inform them about this court order. I would be very surprised if we didn't do that.
Well, as far as this committee is concerned, I would wish to surprise you that that was not done.
What was not done?
No notice was given through any of the ministries that the committee knows of.
That the Ministry of Justice did not write to the Ministries of Agriculture and Environment?
Yes.
Well, perhaps the Solicitor General is in a better position to shed light on that. But having worked with him, based on my personal experience, I would like to believe that there was communications to those ministries. You know, Council, you'll be surprised also to learn that even within the Ministry of Justice itself, communications would come for the attention of the AG, and it would take a month before the AG sees it. That's just the way the civil service is. And again, I keep saying that's why the whole idea of civil service reform was to make sure that there is a more efficient service. But communications get lost, they fall through the cracks, I don't want to speculate as to what happened in this case, but I would be extremely surprised if that were the case.
Yes, and just to react to what you just stated, I would indeed be surprised if the AG would get correspondences a month later. In fact, I would be very disappointed. But I do get where you're driving at, though a month might be excessive.
I probably exaggerated a little,
Yes.
but it will take a couple of weeks.
Yes. So my meager knowledge of the court process, the civil court process, is that once the court makes an order, it leaves it to the beneficiary of that order to facilitate service through the court, of course. I believe you have the same understanding.
In general, yes, in general.
And seeing that there were only two parties, the states and the former president, it would have been deemed by the court to be a done deal that the government was aware and would take control of the assets. Now, I'm not sure whether you had given a synopsis of the order as to what it contains. If perhaps let's let the record reflect what the order directed and to whom it directed to. Please take us through. Do you have a copy of the order?
Yes,
If it's not clear, is it readable? If it's not, then perhaps I can furnish you with a better copy.
You want me to read the whole order?
Not the whole order, but just take us through the main parts of the order and the main institutions or persons referred to in the order. So perhaps let me direct you to 2, 4, 5, and 8.
2, 4, 5, and 8.
Yes, those respective paragraphs.
Okay, paragraph 2.
Of course, paragraph 1 is important because it's expressly granting it.
Is the opening paragraph.
Yes.
All right, I'll start with that. Upon hearing the sector, blah, 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 accordingly, it is ordered and directed pursuant to Section 51, subsection 3 of the Anti-Money Laundering Act, Anti-Money Laundering and Combating Terrorism Act 2012, as follows. 1. That the respondent be and an interim injunction is hereby granted, restraining him, his servants, agents, associates, or otherwise, howsoever, from disposing of or dealing with all movable and immovable properties held by or in the possession or control of the respondent, his agents, associates, and family members, as listed in the annexure marked 1, attached to this order, pending the conclusion of the investigation initiated by the Attorney General into the alleged criminal conduct of the respondent.
All right, let me suggest a different approach now. For 2, perhaps instead of reading it verbatim, just go through it for 30 seconds or so and just decipher out what asset and to whom it is for, to be to whom it is to be bestowed upon.
Well, the order clearly says custody and control of all movable and immovable properties, and custody is granted to the Registrar General
For all movable and
immovable properties.
Yes.
Yes.
So just for the record, what would form part of movable and immovable properties?
Well, immovable properties are mostly landed properties, if you like, and movable properties are anything that moves, cattle, vehicles, I don't know, anything that moves.
That is not fixated.
Exactly.
Let's look at paragraph 4. Just for the record, paragraph 3 is further weighing in on what the Registrar General should be bestowed with.
Yeah.
Let's proceed to paragraph 4. You can look at it for a few seconds.
Okay.
Proceed.
Paragraph 4, of course, is with respect to the livestock, and this was entrusted to the custody and control of the Gambia Livestock Marketing Agency.
Yes. What about 5?
And 5, of course, is, as I said, the wildlife, and this is entrusted or was entrusted to the custody and control of the Gambia Wildlife Services.
All right. That's sufficient. And then the rest, there's also a portion that was supposed to be bestowed to Augustus Prom.
That's right.
All right, we're clear on that for now. Honorable Chair. Honorable Chair. Honorable Chair, I note that our usual time for break is about, but I'm suggesting that we go for another 10 minutes at least before we go on break, so that we go on break exactly at 2:30. If you are amenable to that. Okay. So I was explaining that it is the applicant who would pursue the practicality of the order to ensure that all the tenets of the order are fulfilled. And the applicant here is the government of the Gambia, but precisely the Ministry of Justice, who are in conduct of the case. And here we are, about 2 institutions have not been communicated to. And you rightfully mentioned that the ministry did not have the expertise to preserve wildlife or domestic animals. But did the ministry have a mechanism to ensure that the court order got to its intended destination?
And that's why I said, I explained how government communications work, particularly interministerial communications. These departments are not standalone departments. They may be autonomous in their operations, but they have a line ministry, and there's a permanent secretary in that line ministry. And just like there's a Solicitor General at the Ministry of Justice, and communications are typically between those officials, and then it will be up to those officials to further pass down the communications, the information. So I would not go as far as to say there was no communication with the departments. I can't say anything about that, but I would be very surprised if the Ministry of Justice did not write to the relevant ministries at that time to inform them or convey this order. I would be extremely surprised.
Now, what would you say if I would make a proposition that the government was pressed for time and there was pressure, and the Ministry of Justice, with their expertise, under your guidance, found an ingenious way of approaching the court, and that was through the Anti-Money Laundering Act. And I had mentioned earlier that usually applications like this come from the backdrop of a suit, a substantive suit. Now, this is not the norm. You found an area that would expedite and be more effective for the government. And you shot your shot, and it was granted. But when it came to communicating that decision, we fell back to protocol. What is ordinary? I would have thought that since there was urgency and pressure, that these orders would have reached their intended destination earlier than they did, if they did at all. So that would be to abrogate that protocol of writing to their main ministries, or their line ministries rather, or writing to their line ministries but copying them and sending a copy to them.
We did better than that. We
Proceed.
they were called, I understand, to this meeting. So we reached out directly to them and invited them to a meeting. Again, to in line with your theory of acting expeditiously, we didn't just write. We called them as well and invited them to this meeting. As far as I recall, they were called and invited to the meeting, and they did come to the meeting at the ministry.
All right. Just two contentions on that statement. The first contention is that throughout the life of this committee, we have received evidence as to certain irregular communications, at least in the view of the committee. Now, the committee is aware that phone calls are a very effective way of communicating, but usually in public administration, phone calls are deployed for follow-ups and not for the initial contact. Now, it's that initial contact that I am interested in. That's my first contention, that the phone call perhaps was not the most appropriate way to communicate the order to them. But perhaps what you're saying is that the phone call was to invite them for a meeting, and then in that meeting they will be made known of the order. You can clarify once you have the floor. But my second contention is that we received evidence that they were not in the meeting. None of them. That is the Department of Wildlife. I don't believe it's actually called the Department of Wildlife, but for ease of convenience, let's refer to it as Wildlife. Wildlife was not part of those institutions in that meeting. And Gilma, which is the Gambia Marketing Livestock Agency, was also not part of that meeting. Okay. Would you be surprised to note that?
Yes, indeed. And for the simple reason that I would have expected Ministry of Justice staff to be able to convene. In so far as I recall, that was the briefing, that they were going to be invited to a meeting to be informed of this order. But let me go back to your first point of contention about the so-called irregular communications. You know, I will have to go back to context here, because it's important for all of us to be on the same page. You know, Council, the freezing order was obtained in May, the first one, May 2017. I believe the president returned to the country in February. Correct me if I am wrong. I can't remember, but I believe it was in February. I certainly came in February, got sworn in, came back in March, April, May. When I came back to the ministry, after not having worked at the Justice Ministry since 2000, almost 2 decades after, I found the ministry with the same modus operandi as I left it 20 years earlier. In other words, to even get a letter typed out, there were a pool of typists, maybe 2 or 3 who were at the criminal division, and maybe 1 or 2 at the civil division, and state lawyers were writing their legal opinions, their letters, their correspondence with pen and paper. And then each of them would submit those handwritten opinion and legal advice to the pool of typists, who will take turns to look at each file, each assignment, to type it out and give it back to the State Council to review, etc. This is how mechanical and tedious it was. this is what I found at the ministry at that time, that it would take days, if you want, for even a simple letter to be typewritten and be sent out. And that's why we resorted to making phone calls. So it may be irregular to you today, and it may even be irregular to the ministry today, now that every state lawyer had a desktop in their offices. But at least when I was leaving, I managed to get that for them. But at the time, no state lawyer had a desktop in their offices. Some who had computers were using their personal laptops, and it was the pool typing system that we had. So if we were to wait for the secretaries to type these letters so that we can send them, that would take days. And these orders needed to be implemented immediately, urgently at that time. So you can see we didn't have the luxury of time, of the time that you have now, and label those communications irregular. It was, I keep saying, the best we could do at the time, giving the resources and the environment. So, but if the second contention is that members of the Department of Livestock and Forestry, Wildlife, were not in that meeting, I would be shocked. I would be surprised. But again, like I said, the instructions as far as I was concerned and the feedback as far as I could recall was that they were meeting. It was called the implementation meeting, if I remember correctly. It was a meeting to discuss how to implement the court order. So I am very surprised that those who were given a role in the order did not participate in any meeting at the ministry. I am very surprised about that.
All right. What about the instructions? How were they communicated to the team that were supposed to enforce the order? Were they also verbal instructions?
There was a lot of verbal instructions at the time, particularly when there are not contentious issues. Yes, I mean, in the ordinary course of your work, you give verbal instructions. That was quite common. As I said, if not for anything else, but for the fact that it would take an inordinate amount of time to be typing out these, type out instructions to staff within the ministry.
Of course. All right. I believe this is a convenient point to stop, Honorable Chair. For want of being crucified by the Sisekundas, I would stop here and resume after the break.
Thank you so much, Council. Yes, very well. I think it's a convenient point for us to take a break for our usual prayers and lunch. Remember, there is always prayers before lunch. Yeah? That's for the Turekundas as well. Thank you. So we will come back at 3:30, at least 1 hour, so we can proceed with the testimony again. Thank you. Meeting adjourned for now. Thank you.